Washington Journal continues.
We want to welcome to C-SPAN Paul Williams, who teaches law at the American University here in Washington, D.C. Good morning. Thank you for being with us.
Good morning, Steve. It's my pleasure.
We want to get some background information on a court case the U.S. Supreme Court took up in 1942, the Geneva Convention, which met in 1949, and how all of that relates to these military detainees, now about 30 plus in Cuba at the Guantanamo Bay base. First of all, prisoners of war versus unlawful combatants. What's the difference?
Well, there's a very, very important difference. The conventions were designed to protect non-combatants and individuals who are no longer a threat. A prisoner of war is an individual who is no longer a combatant. He or her has surrendered their arms and they've been taken into custody by the opposing forces. An unlawful combatant is an individual who at all times is a threat to the civilians and other non-combatants. You don't show your arms, you don't wear an insignia, you don't respond to any particular command and control structure, and therefore you're deemed a particular threat to the security of the civilians of both your state and opposing states.
Let me go back to this 1942 case, and there are a couple things we want to show our audience on the screen and they can follow along. First of all, on the issue of lawful combatants, that they're subject to capture and detention as prisoners of war by opposing military forces. Unlawful combatants, likewise subject to capture and detention, as you just said, but in addition, they are subject to trial and punishment. What was the case that this came from, and what has resulted from it?
Well, this came from the case of the 8 Nazi saboteurs who were landed in New York and Florida in 1942. And the idea was, in the 40s, it was very, very important in order to draw a distinction between those individuals who were targeting your military forces, and thereby they were lawful combatants, and if you apprehended them, they would be prisoners of war and returned to their home country at the end of the conflict. The other category, which are unprivileged combatants, because they are unlawful combatants, are essentially bent on committing civilian atrocities or engaged in unlawful behavior in an international conflict, and therefore they pose a particular threat to civil society, to civilians, and those individuals are committing crimes, and therefore they're not protected by the Geneva Conventions, and they may be prosecuted by a competent tribunal.
One other part from this 1942 case that says, our government, by thus defining lawful belligerents entitled to be treated as prisoners of war, has recognized that there is a class of unlawful belligerents not entitled to that privilege, and they point to Article 15 of the Articles of War. Can you explain?
Yes. Well, I think this is very important. Even in the early 40s and then in the late 40s with the Geneva Conventions, there was a sense that there would be a growing or an increase in unconventional warfare. Up until that time, most warfare had been between two armies. What they were, in a sense, predicting is what we have now, which is a terror war. Our combatants, or the adversarial forces, are bent not on attacking our military forces, but on attacking our civilians. And so the question is, are they entitled to legal protections similar to those which would pertain to military combatants? And I think they were very, very clear, very prescient in the 40s in understanding that we would have an increasing degree of unconventional attacks, and you need a deterrent. And the deterrent to stop these unconventional attacks is that if you're apprehended, you will not be entitled to protections due a normal military officer or military combatant.
We want to bring this to the case today. There's a front page story below the fold in USA Today, but as a way of further background, the Geneva Convention, which met in 1949. What came out of that meeting?
Well, the Geneva Convention produced a series of 4 protocols, which were primarily designed to protect civilians and individuals who were combatants but were no longer a threat. So you have the first and second conventions are on wounded and sick prisoners. The third convention is on prisoners of war, and the fourth convention is on targeting civilians.
What other issues should people understand as we move into the discussion making headlines today?
Well, it's very important to understand that the crisis that we're facing now, or the conflict that we're currently facing, really wasn't envisioned to a significant degree by the Geneva Conventions. So we're trying to apply a set of rules, which although to a certain extent they did foresee this new terror war that they have, didn't foresee that the entire set of opposing forces would be bent on terrorism and unconventional warfare directed at civilians. And so when we're trying to figure out what are the rights and privileges of the Al-Qaeda detainees in Guantanamo, we can look for guidance to the Geneva Conventions, to the 42 case, and to something called the Covenant on Civil and Political Rights, but they're not going to give us any clear answers. We're going to need to be very creative and very cautious in developing a new legal regime to protect their rights, but also to deal effectively with this new terror war.
We're going to continue to come back to these issues to explain to our audience, but with that background, we welcome your phone calls. We are hearing from first-time callers today, 202-737-0001. That's the line for Democrats. 202-737-0002 for Republicans, and 202-628-0205 if you're a member of a third party. Andrea Stone has the story. Washington is the dateline. The headline in USA Today says some detainees shaved and duct taped. She writes that as 30 more al-Qaeda and Taliban prisoners joined 20 already being held at Guantanamo Bay on Monday, among the details emerging in their new lives is that many have been shaved, some have had duct tape around their arms and legs, and they're being served bagels, which is a food rare in the Arab Middle East. Military guards on transfer flights have duct tape to restrain the unruly prisoners, and all the prisoners that have made the 27-hour trip to Cuba have been shackled to their seats. A detainee on the first flight was taped down. Pentagon spokeswoman Victoria Clark says that these measures are needed because the prisoners are extremely dangerous.
Yes. My reaction to that, and that's a very important indication of the different categories of unlawful combatant and prisoner of war. Again, a prisoner of war is an individual who's no longer a threat. These individuals, even though they're in our custody, remain combatants. And that's why they are denied the general rights and privileges, although I'm not sure giving them bagels is a violation of their international rights. They're denied the basic rights under the Geneva Convention because if they were set free tomorrow, they would, commit terrorist acts or still be engaged in combat. A prisoner of war generally is not. They've surrendered their arms and they're no longer going to engage in combat. These individuals are continuing their mission of combat against American civilians. And that's why they're concerned.
National Public Radio has also been focusing on this issue, and yesterday, among the discussion, the facilities where these detainees are now housed, many of which have a metal roof, but the sides that are open so rain and other weather conditions would be impacted. These folks would feel that. And the question that came up yesterday is whether or not human rights groups will be allowed to go down and check out the conditions. Is that part of precedent either from the Supreme Court or the Geneva Convention?
Well, I think this is where the administration and the human rights groups are going to have to be creative. I think if we look at international law, it's clear that these individuals still retain their combatant status and they're unlawful, so they don't have these rights and privileges. Yet, you can't simply say that and lock them all in a pen in Guantanamo. The United States is committed to international standards. It's signed the Covenant on International Civil and Political Rights. And there's an obligation on the United States to try to tease out the purpose and the intent of human rights standards and the Geneva Conventions. And I think it would be perfectly appropriate for the human rights groups to be granted access to these detainees, not to have a checklist to make sure that every single thing with the Geneva Conventions, which are inapplicable, are complied with, but that the general norms of human dignity are applied to these individuals. They're unlawful combatants, but they're still human beings.
So let's go back to some definitions. A prisoner of war is what?
A prisoner of war is an individual who no longer poses a threat. It was an individual who was dressed in a uniform, had a weapon, and you were an opposing soldier and said, my job is to kill you. Somehow you injured me or I surrendered, I'm no longer a combatant. So you hold me in jail for 2 or 3 years until the war is over, then you send me back to my home country. An unlawful combatant is an individual dressed in civilian clothes who is intent on killing you, a military officer, but without you knowing it, or attacking civilians. And then once they're arrested, they continue to harbor. These individuals presumably continue to harbor their terrorist intents. So they're no longer innocents, non-combatants. They've no longer transformed themselves back into civilians. Tomorrow they would commit these atrocities again. Prisoner of war goes back, the war is over, they go back to the farm, back to the shop, go back to civilian lives. It's not the case with these individuals.
Why have you been studying this issue?
The reason I've been studying this issue is trying to grapple, like most public and national lawyers, with where do we go from here? The Geneva Conventions aren't that applicable. There are some international human rights standards. They're somewhat vague. We have a new crisis facing the United States, a terror war. How do we respond? Domestic courts aren't particularly well tooled in order to respond. Therefore, we have the creation of a war crimes tribunal. Can't create war crimes tribunals or military tribunals without some form of due process. And so there's essentially a whole open field. How do you deal with this new terror war, protecting our security, but at the same time, basically meeting international standards?
Our guest is a graduate of the University of California at Davis and also Stanford University, where he earned his law degree. He also earned his PhD from the University of Cambridge, teaches here in Washington, D.C. Professor Paul Williams. Next call on the Democrats line is DeSoto, Texas. Good morning.
Hi there. My question was concerning international law And do we, at this point in time, have a legal basis to actually attack Iraq?
In order to attack Iraq, we would have to act in self-defense. The idea being that Iraq would pose an imminent threat to the United States. And a couple of decades back, Israel attacked an Iraqi nuclear power plant on the argument that they could then make nuclear weapons and would attack Israel. There's two bases for attacking Iraq. One is that they do pose an imminent threat to the United States, and therefore the United States could act under its obligations or its rights under the UN Charter in self-defense. Or second, that Iraq is in violation of numerous Security Council resolutions which do in fact provide for the use of force. The question is, what is our objective? Can we go in to try to make them comply with the Security Council resolutions to allow inspectors, or can we actually seek to topple Saddam Hussein? The important question here is, what is the practical policy for doing that? I believe a legal argument can be made. The question is, how do we actually accomplish that?
Next call is New York City. Good morning. You're on C-SPAN.
Yes, good morning. I'm an attorney and independent. My name is Abdul. I'm calling from New York City. Isn't it true, sir, that in a war, the winner makes the rules? It happens in every war in history, regardless of what the so-called international law is. Secondly, isn't the purpose of a trial, whether military or not, to find the truth, and therefore to classify people as non-citizens and deny them certain constitutional protection? It's like saying, look, we're not really interested in finding the truth with respect to non-citizens. And the third thing, you keep citing decisions from 1942. This was a time when the Supreme Court also found that the internment of Japanese Americans were constitutional. We're living in a totally different country. It was segregated back then. We had a totally different standard. The America of 1940 is not the America we should be proud of today. Is there any more recent decision that would be authoritative on this issue?
No, those are three important questions. Let me start with the first one, the winner-take-all. You're right. Up until very recently, up until the 40s, the rule was the winner-take-all. And the Geneva Conventions were an attempt to change that. In particular, in Vietnam, the United States decided to apply the Geneva Conventions in hopes that the Viet Cong and the North Vietnamese would apply them as well, and they did to a certain extent. So there's a sense now that we try to create rules based upon reciprocity, which is why it's so important that we have a situation here which the other side has not only said they won't abide by the Geneva Conventions, but that they in fact intend to target civilians. So they've essentially said, we're not going to abide by any rules. The second element is that the purpose of any tribunal, be it a domestic court or a military tribunal, is to determine the truth. The question is, what standards do we apply? Do we apply U.S. constitutional standards, which are, quite frankly, the highest in the world, or do we apply international standards drawn from the Yugo Tribunal, the Yugoslavian Tribunal, or the proposed International Criminal Court, or even the Irish, the Spanish, the Italians, the French all have terrorism courts, which apply a lower level of standard than our constitutional protections, but are designed to find out whether this individual is in fact guilty or innocent. And you're right, that must be the objective of these tribunals. And then the third point is a similar point to what I was trying to make, is in the 42 case and in the 1948 conventions, they're in a sense old law. And the problem is we don't have any new law. We haven't had a conflict. Even if you look at the Iraqi conflict, the Yugoslav conflict, the other side wore uniforms, showed their arms, and at least with respect to our military forces, engaged the military forces. They did commit crimes against their own civilians. The Al-Qaeda is the first instance where we have the opposing forces, none of which are organized in a military structure, and all of which are trained and bent on attacking civilians. So this terror war is something that we simply don't have rules to apply, and we're making them up as we go along. And I would argue that we have to have some flexibility, but we also have to comply with international standards, or at least the intent of international standards.
You talked about this briefly earlier, but what led to and what was the Geneva Convention?
Well, the Geneva Convention, what led to the Geneva Convention were the atrocities committed in World War II and World War I against civilians, and also prisoners of war, military officers and other individuals who essentially surrendered and said, okay, we're prisoners of war, we're no longer a combatant. And then they were tortured, they were detained in an inhumane manner, and there was a sense that they're no longer a threat, and therefore they should have certain rights to be treated with dignity and return to their home country afterwards.
And when you talk about civilians, this government also housed Japanese Americans. Was that part of this discussion?
And that was part of the discussion, is how do you treat not only civilians from the opposing side, but your own civilians. The conventions were in 1948, so they were after the conclusion of World War II. And there was the question, there was the obvious recognition that many things went badly wrong in World War II. And so there was a sense to create a set of rules so that you wouldn't target civilians, you wouldn't detain your own civilians, and you wouldn't essentially commit atrocities or torture individuals who were no longer a threat. And I think that's the nub of the argument here is, are these individuals still a threat? Because a lot of the rights and privileges that you would give a non-combatant, such as setting them free at the end of the hostilities, we're not about to, defeat the Afghan government or the Taliban, defeat Al-Qaeda in Afghanistan, and then 6 months from now, set them free, because they will then continue to be a threat to the United States. And so the key is when an individual transforms into being a non-combatant or no longer a threat or an innocent, essentially.
Were these rules or guidelines in place during the Vietnam War when Americans were being held in Vietnam?
Now, that was a very interesting situation. In Vietnam, the American forces were bound by the Geneva Conventions because we were a regular army. The Viet Cong was an insurrection or rebellious force or belligerent force. They were not technically bound, which has meant that we could summarily execute and engage in certain activities in violation of the conventions. We made a policy decision that we would apply the Geneva Conventions to the any detainees we came across that were the Viet Cong in the hopes that they would then apply them to our forces. And there was, in a sense, a tacit agreement that we will treat you as military combatants and prisoners of war with rights and privileges, and you will treat our pilots who were captured with rights and privileges. And so we created an informal legal structure to protect the rights as much as possible of those involved. In this case, the combatants have said, we're going to attack your civilians. We're not interested in the Geneva Conventions. And that's why it's reciprocity. They can't then seek protection in the Geneva Conventions if they themselves have explicitly articulated that they are opposed to those and are in fact targeting civilians.
Somerset, New Jersey, good morning. You're on the air with Paul Williams on the Democrats line. Hello, caller. Somerset, New Jersey, good morning. We'll go on to Tampa, Florida. Good morning to you.
Yes, my question is a follow-up to the Iraq question. As I understand it, the professor essentially said that an attack on Iraq would be legally justified because of the UN resolutions and so forth. My question is there any aspect or feature of international law that would call for the direct targeting of a head of state as opposed to an Article 42 style call for aerial bombardment or sanctions or whatever that only results in more casualty? Is there any feature of international law that would specifically target a Saddam Hussein or some other, that has been deemed by the international community to be an imminent threat?
Yeah, there's two relevant legal rules that apply here. The first is proportionality. If you were to use the Security Council resolutions, they are designed in order to promote the transparency of Saddam Hussein's weapons of mass destruction program and chemical weapons program. If you were to use the Security Council resolutions, you couldn't target Saddam Hussein because that's not a proportional response. You would have to engage in further airstrikes and degrade his capacity to make weapons of mass destruction. If, however, the United States had evidence that Saddam Hussein possessed weapons sufficient to create mass destruction and intended to or was about to use them, then you could target that individual as part of the command structure. The other important point here is Saddam Hussein is a military officer as well as the leader of Iraq. And there's a general law against political assassination. You can't just assassinate leaders that you don't like, but in acting in self-defense, you can seek to topple a regime or target a regime wherein that individual is the military commander and is posing a direct and imminent threat to your own national security.
North of the island of Jamaica and in the southeastern corner of Cuba is Guantanamo Bay, where the Americans have a military base, and we'll show it to you on the map to give you a geographic perspective of where these, right now, 50-plus Taliban and Al-Qaeda members are now being housed. Many more expected. Early estimates say that as many as 2,000 could be at this military base over the next couple of months. Next call is Arksdale, North Carolina, Republican line. Good morning.
Hey, how you doing?
Morning.
Morning. Three quick things. One is the temperature in Key West, Florida, which is not that far from Cuba, is 76 degrees. These detainees, of course, are used to being frozen. The second, we are feeding the detainees. And if you look at Afghanistan, there's people over there that are starving to death. And the third quick point is I think that we should be deducting the expense of upkeep of the prisoners from the Al-Qaeda and from the Taliban. Just 3 quick items.
Thanks for the comment. We'll go on to Guilford, Connecticut. Good morning on the Democrats line.
Good morning, Mr. Williams.
Good morning.
I'm curious. Number one, how have these people been detained by whom and under what evidence? And number two, it doesn't seem to me that based on the way the whole Al-Qaeda network is set up that they ever will be non-combatant. So now they will never not be a threat. So what happens to these people for the rest of their lives?
Well, that's the crucial question here, and Steve had asked earlier, what current international laws and rules apply, and this is the conundrum. To answer your questions, they've been detained either by U.S. military forces or the Southern Pashtun tribes or the Northern Alliance, who are our allies in this conflict, and then transferred essentially to the custody of the U.S. armed forces from the ground in Afghanistan. So we've come into to possession of these individuals in a lawful manner under international law. The question is how you determine whether, in fact, they were unlawful combatants. And here the Geneva Conventions and international law provide that a competent tribunal must determine this, which leads to the question of what is a competent tribunal. We're not going to be able to process, I guess we currently have 400 Al-Qaeda detainees, and we'll have about that many soon in Guantanamo, in the Southern District Court of New York, or in San Francisco District Court. So we've created these the U.S. government's created these military tribunals. Question is, do they provide for a full and fair trial? The executive order had a number of gaps in it, and it was rightly criticized, and the hope is that the Department of Defense will issue rules of procedure and evidence which comply not with the U.S. Constitution, but with international standards of due process, and that we will actually determine whether these individuals are in fact guilty. An important point to note is that in the Nuremberg trials, 15% of the defendants were found innocent. In U.S. trials, it's only about 6 or 7% which are actually acquitted. So they did apply a certain level of due process and were fair in their evaluation, and hopefully the military tribunals will be the same.
As long as we're trying to explain the different processes involved, military versus civilian trial, what's the difference for a lawyer, for a judge, and or a jury?
Jury, there is no jury in a military tribunal, at least as defined under the President's executive order. For the defendant, it's the question of their rights. If you're a defendant in a civilian trial and you're an American citizen or a resident of the United States, you're entitled to a variety of due process protections. And let's be honest, they're the highest in the world. If you are before a military tribunal, we haven't had one of these in a long time in the United States. It'll depend what the rules and procedure of evidence are from the Department of Defense. But for instance, here, let's say look at the Yugoslav Tribunal, which is not a U.S. domestic court. Hearsay is admissible. The prosecutor can appeal an acquittal while the detainee remains in jail, and you can even have essentially a trial in absentia under certain circumstances. And so there's a lower threshold, but you're entitled to choose your own attorney. You're entitled to confront your witnesses, and you're entitled to have a qualified bench which hears your case.
If you're deemed to be an unlawful combatant, you're facing the military trial, you're found guilty, then what happens? How do you determine punishment?
The punishment will be determined based upon the seriousness of the crime. Were you simply an unlawful combatant who was a member of Al-Qaeda, in which case it's probably 5 to 10 years, or were you actively engaged in aiding and abetting or planning or carrying out terrorist acts which targeted other non-combatants or targeted civilians? In that case, you're likely to find the death penalty. And it's important to note here that over 130 countries in the international community have the death penalty. Hopefully it will be not used at all or very rarely used in these circumstances. But if you look at international standards, 50 countries are opposed to the death penalty, then 130 have them, and mostly when they have them it's for terrorism and war crimes.
How long have you been teaching law at American University?
6 years at American University.
Next call, Fort Worth, Texas, for attorney and Professor Paul Williams. Fort Worth, Texas, you with us?
Hello.
Good morning.
Yes. I was just curious about the young man that was fighting with the Taliban, and it seems to me that he's a mercenary.
Yeah, he's the very difficult case because he was and may still be an American citizen. There's a very strong argument that he should be tried before an American court and afforded due process rights. The other argument is that he was a mercenary, and through his engagement in those acts, he relinquished his American citizenship, and he could be appropriately tried before a military tribunal. Now, he's an individual which would fall into this non-combatant. Wasn't wearing a uniform, wasn't wearing an insignia, and wasn't engaged in any sort of lawful combat. And it sounds bizarre to say there's lawful combat, but there are rules for conducting war.
A. Williams from Augusta, Georgia has emailed this: isn't it true that the United States is one of the only countries in the world to actually follow the Geneva Convention rules during times of war, and haven't most countries committed horrific crimes against war prisoners despite belonging to this convention?
I think that's a fairly accurate observation, and it's important to understand that background is important in understanding why the United States is behaving in the way that it is. A number of countries are increasingly following the conventions and the laws of war, but these laws are not self-executing. Slobodan Milosevic didn't look up the rules of war and then abide by them, and in fact he committed genocide against his own civilians. So there are a lot of mean and nasty characters out there. But the way in which the rules are enforced, because there is no international policing mechanism, the rules are essentially, we have a set of rules from the Geneva Conventions. We will abide by them if you abide by them. Now, there's no mechanism to keep you from failing to abide by those rules except for the sanction of, if you don't abide by them, we won't. And if we win, you'll be detained as unlawful combatants and you won't have any rights. And so it's a very draconian response, which is why we have this sort of, people are scratching their heads and saying, well, what do you mean these detainees have no rights? That's the enforcement mechanism. That's the incentive to abide by the rules of law, that if you are then captured or you do lose, you're treated according to these rules. But if you fail to abide by them during the conflict, you have no rights. Now, I would argue we still have to provide rights under international standards, but that's the way in which this mechanism has been set up. Because again, international law is not self-executing.
From the Republican line, Gainesville, Florida, good morning.
Good morning. I have just a couple of comments regarding the impending human rights activists that are going to be going over and inspecting the prisoners. First of all, I think they're having it now better than they've ever had it in their life, being in the Caribbean and having food, medical attention, etc., etc. Wouldn't it have been better to send them up to Alaska, where they could actually suffer a little bit? And the other thing is, I personally think that John Walker should be treated as a traitor, because I think that's what he was.
I think you've touched on a question here of, what are the appropriate standards? We often find ourselves in a time of war in custody of individuals who, having it in a situation in custody, might arguably be better than their current situation. But they're entitled to that in terms of, under general international standards and generally under our moral obligation to treat them as human beings. But it's also important to remember that they're not automatically entitled to U.S. constitutional standards. They're not entitled to everything that an American citizen is entitled to. I think that's the debate. We need to find some middle of the road where not every detainee has U.S. constitutional protections, but at the same time that we don't send them to Alaska. I think you have to pay people to stay in Alaska sometimes. We'll get Alaska calls now. Sorry about that.
Actually, we'll get another call from Florida on the Democrats line. Homeland, good morning, for Professor Paul Williams.
Yes, sir. I was wondering, considering that some of the detainees were captured in Afghanistan and not captured, plotting against civilian targets in the United States, how does that relate to the individuals captured in the United States from Germany and applied unlawful combatants to them? Thank you very much.
Sure, and that's an important question. And international law has essentially said that it's not relevant where you're captured. What's relevant is the type of combatant or non-combatant that you are, which is defined by your motives and your intentions. If you're a German on the beaches of Florida bent on sabotage, or if you're in Afghanistan training how to make a dirty nuclear device or some other type of terrorist, engage in some other type of terrorist plot, you're still an unlawful combatant. So it's not where you're captured. Your citizenship is relevant, but where you're captured is not relevant. It's your intentions.
Next, from the third party line, New York City.
Good morning. Thank you for C-SPAN. I'm not an attorney, and as I'm sure these questions will show, quite ignorant about international law. I wonder whether there seems to be some confusion or a muddling of Al-Qaeda versus Taliban in terms of the detainees? Because it seems to me, again, as someone who's quite innocent, that the Taliban can at least make the argument, or have it made for them, that the fact that they weren't wearing uniforms is irrelevant, since there is no history in Afghanistan of anybody wearing a uniform, perhaps in the Western sense. And certainly anybody who's seen any of the videos about the resistance to the invading Soviets saw people who were dressed very much as the Taliban were, or presumably are. And shouldn't those individuals be treated somewhat differently from Al-Qaeda? They seem more like prisoners of war, if you will, since the Taliban, even though we didn't recognize them as an actual government, was recognized by Pakistan, Indonesia, and Saudi Arabia. So that seems less clear to me than the accusations and the treatment of the Al-Qaeda. The other thing, and this is purely a subjective comment, I think one of the things to be proud about America is that it's always resisted the kind of base instinct to wreak revenge the way that many of our enemies would had they been triumphant. And I've heard on several television commentaries as it relates to the sequestering of the detainees in Guantanamo, that they're being treated too easily. Yet, to my eye, their quarters seem to me to be a form of concentration camp, taking concentration camp literally and not metaphorically. And plus, I noticed that several commentators talked with some glee about subjecting all of these people to having their hair shaved off. And I think to some of these individuals, that's a religious thing. Having long hair is, in fact, an Islamic significance, rather than simply a place to hide hand grenades, as was suggested by one overwrought commentator.
I'm going to stop you there. You put a couple of issues on the table.
Yeah,
Appreciate it.
You've got three very important issues. And the first one is the wearing of the uniforms. It sounds very technical and very lawyerly. What's important here is that they have to dress in a way that makes them distinct from civilians. And in fact, the Taliban, to a certain extent, did this. The importance there is that the opposing army then doesn't look at 15 civilians and can't figure out which ones are the combatants and which ones are the non-combatants. And that's why it's important, this wearing a uniform or wearing an insignia. And if you flip through the pages of any newspapers, even this last week, you see the Columbia rebels, you see some of the rebels in Macedonia, they're all wearing uniforms or some type of insignia, so you know they're not a civilian, so you don't actually target civilians accidentally. The Taliban is very crucial and very important because they are less likely, at least the rank and file, to come into U.S. custody, and they are more likely to be protected by the Geneva Conventions if they were wearing some type of distinct garb or distinct clothing. And I think what we're finding is most of the Taliban are in fact being treated or are being held as prisoners by the current Afghanistan government, and they should be provided with prisoner of war protections because they are now innocent, they are non-combatants, and they will basically go back to their farms and their shops. The question, however, is whether these Taliban have committed domestic crimes in Afghanistan or war crimes. So once you get past the question of what's their status, unlawful combatant or POW, you move on to the second question of, well, have they committed any war crimes, and therefore should they be tried by the Afghan forces or by some international tribunal. And your last point was very, very important, which is sort of the base instincts. And this is why you have international law to sort of guard against people acting on their base instincts. And it's also why it's very difficult to implement international law, because people, governments, armies do act on their base instincts. And my point that I'm sort of making here is we're in a very precarious situation, because if you look at the international law that exists, it either doesn't really apply to the circumstance, or it particularly doesn't apply to the Al-Qaeda members because they're unlawful combatants. But that doesn't mean then that we can all act on our base instincts. We then have to ask ourselves, okay, how do we have a full and fair tribunal? How do we give them some sense of due process? And how do we do what's morally right? It's very difficult because you can't just download a set of international standards, which you could, for instance, in the Yugoslavia conflict. All the law was written, you just downloaded it and applied it. In this conflict, it's going to be very difficult.
And let's again go back to this decision which came out July 31st, 1942 by the U.S. Supreme Court, which follows up on the caller's point about an enemy combatant who, and this is a quote, without uniform, comes secretly through the lines for the purpose of waging war by destruction of life or property, are familiar examples of belligerents who are generally deemed not to be entitled to the status of prisoners of war, but to be offenders against the law of war, subject to trial and punishment by military tribunals.
And I think that's very important. Of the 8 German saboteurs, all 8 had lived in the United States, and 2 were in fact American citizens. So the question is, how do we protect ourselves against 2 American citizens and 4 individuals who are German but had lived in the United States for extensive periods of time? Well, we have criminal mechanisms, we have military mechanisms, but the legal mechanism is we say to you that if you're going to engage in that behavior, you have no rights once you're captured.
Arlington, Virginia, good morning. Republican line.
Oh?
Good morning, caller.
Oh, good. I was shot down in July of '42, and I was a prisoner of war in a German prison camp for 2 years, till I fortunately got out of there. Now, I served on a 3-man committee elected by the other prisoners to deal with the bosses there, to demand our rights, what have you. Germans generally held up the international law, but they also made it very clear that when there's any doubt about where they stand, they would take whatever action they had to keep their people safe. For example, under American law, as an officer, you have a duty to try to escape. So I approached them and told them that is our duty, and that we're going to do it whenever we can. You know what their response was? Their duty was to shoot us if we tried to, and we understood that. And I think down in Gitmo, the first thing we have to put for anything is the safety of the military men guarding these prisoners who are a danger spot.
Caller, where were you detained in Germany?
Where I was in Hamburg, right outside of Hamburg, for 6 months. Then I went, just a little bit north of Berlin for most of the rest of the time.
And were you in the Air Force?
I was in the Air Force. Well, Airco at that time.
Thank you for the call.
Okay.
No.
Did you want to talk? Caller, you still with us?
Or I could just make a comment, I think, on that was very crucial and a very important observation, because what you found is that the Germans were willing to provide the prisoners of war their international rights and humane treatment to a point. And the point was when the prisoners stopped being non-combatants or innocents. If you're a prisoner of war and you're waiting out the war, you're not a threat. But as the American prisoners were instructed to try to escape, you try to escape, by whatever means you can, which might include killing those who your captors. And when you cross that line, you're no longer a non-combatant and you are a threat. And I think the question is, how do you determine when these Al-Qaeda members in Guantanamo have become innocents?
Moultrie, Georgia, Democrats line, good morning.
Good morning.
Morning.
To the professor. As a student, I was told that we were looking for truth. And as a professor, how do you rationalize, not objectively, and be so pro-U.S. of A, and you take people out of their country and fly them all the way across the world, and you justify them being treated like black people are still being treated in America.
I think the important point here is that some mechanism very rapidly has to be put in place to ascertain whether in fact these individuals detained in Guantanamo are combatants in this terror war, are unlawful combatants. And the hope is that will be done, it must be done through a full and fair process. And there should be a lot of sort of scrutiny of these military tribunals and the rules and procedures of evidence that are coming out from the Department of Defense.
Our topic is the treatment of these military detainees. Next call is Orangeburg, South Carolina, third party line. Good morning.
Yes. Thank God for C-SPAN, and good morning to you all. I got a question about the previous question on the caller about shaving of the hair, saying that is a religious belief on the Taliban part. I want to know if that's a Geneva Convention rule that the hair must be shaved, or is it a...
And let me just point out, because there have been a couple of calls on this, according to the Marine Lieutenant Colonel Dave Lappin, who is a Pentagon spokesperson, saying, this is from USA Today, it's not to embarrass them, it's because they were infested with lice and there is no place to take care of them in Afghanistan. The decision was made for safety and hygiene reasons.
Yeah, this is a balance, and this is what international law is all about, and this conundrum that we're having. is the Geneva Conventions provide that you can't be discriminated upon based upon your religion, and that you are entitled to your religious practices consistent with security. And that's the question is if having your head not shaved is a religious practice, that's important, but if there's some security element or health and safety element, you have to balance those. Now, I don't know what the right answer is. What you might do is look to sort of, in this case, U.S. domestic standards. And I think you'd find that there's a history of maybe this type of treatment early on. Now, the important point is also in this is do these individuals stay in Guantanamo indefinitely? Is this just sort of a transit point? Is this a preliminary detention before any type of judicial tribunal? And then are they moved on to more long-term accommodations where they will have a level of treatment consistent with other prisoners in the United States? And I think that's a lot of questions should be asked about that, and basically where do they go next and how long will this last?
Last call, Republican line, Smyrna, Tennessee. Good morning.
Yes, gentlemen, I'd just like to make a statement. The detainees that we're talking about human rights and how they're being treated. What about the right of the families of the military troops that are fighting in Afghanistan? What about their rights and their standard of living? Thank you.
That's crucial, because this goes back to the very early point of the status as unlawful detainees. And what you're trying to do through basically the applications of the rules of law, saying these individuals are unlawful detainees, they're not entitled to the basic rights that other individuals are entitled to, is to deter that type of future behavior. Now, I'm not sure we're going to be effective at that, but that's how you protect the rights of the servicemen and their families fighting in the region, is you essentially say that there's a set of rules, we'll abide by them, and if you abide by them. And in fact, we'll abide by them first. And if the other side says, well, no, we're not going to abide by them, we're going to target, and we're going to engage in unlawful warfare by targeting civilians and other types of activities, then those protections basically evaporate. And again, the point is they can't evaporate so far that we act on our base instinct, but you have to comply with the national standards, but you don't have as high level of standard as you would have for lawful combatants or other types of prisoners. And that's the enforcement mechanism.
Before we let you go, do you think at some point when we move beyond this current issue, there will be another Geneva-like convention and another set of standards based on what we've learned over the last couple of weeks?
Yes, there was an attempt in 1977 to create a new set of standards to apply to belligerents who tended to dress in civilian garb. That is not enforced, has not been signed by the United States for a variety of reasons, in part because they feared it would encourage this type of activity. But I think what you'll have is state practice. Countries will look at how the United States in fact treats these prisoners, how full and fair of the due process standards that are applied to the military tribunal, and that'll be relevant for any future conventions or for the future conduct of this terror war.
Professor Paul Williams, author and professor of law at the American University, the Washington College of Law here in Washington, D.C. Thank you.
My pleasure. Thank you.